Hello, my name is Jack Carney DeBoard from Jack's Law Office, where your needs come first. Today's video tip is with regard to a dissolution. And the question that comes up all the time in the office is this: do I have to disclose all of my assets and liabilities? Do I have to disclose my retirement account? Do I have to disclose cash that I may have in a certain account? Answer: absolutely yes. The idea in a dissolution is that both parties have disclosed all assets and liabilities so that they can make an agreement, which goes in your separation agreement, that is fair and equitable. And in order for that agreement to be fair and equitable, each spouse must know what the other has as far as assets and liabilities. Now, you may think, well, what's going to happen if I don't disclose? Well, there has been certain changes in the law in the last couple of years which would result in very difficult penalties and possible circumstances after the fact, such as if one spouse finds out later that the other spouse did not disclose sums of money or accounts that they had at the time of the filing of the dissolution or at the time that dissolution was completed, then the other spouse can bring an action against them after the fact. And this could raise more problems than it would have ever been worth if the assets and liabilities were disclosed up front. That is the law of Ohio, and there are several things that will happen in your dissolution to make sure that that does in fact happen. Number one is there's certain paperwork, certain required forms that each side must fill out. And I repeat, each side must fill out. What that means is each side fills out their own asset and liability disclosure statement. So the tip here is for each spouse to carefully read. Don't just sign off on your separation agreement. Don't just answer yes to the questions in your dissolution hearing to terminate the marriage quickly. Rather, think, listen, read, and make sure that you're comfortable that both sides have disclosed, that the other side, in your case, has disclosed all of the assets and liabilities that you're aware of, or even that you have a hunch that a certain asset and liability is out there. Otherwise, don't sign the separation agreement and don't sign the dissolution final decree. That's the video tip for today on whether or not you have to disclose all your assets and liabilities in a dissolution. I'm Jack Carney DeBoard from Jack's Law Office. If you have a question about disclosure of assets in a dissolution case, please pick up the phone and call me at 740-369-7567. Thank you.